being settlement ready is just making sure that you have workflows and processes in place once the case resolves.
Sam, you and the people over at Milestone work with some of the most successful trial lawyers and law firms in the country. As you know, so much of the work begins once a lawyer settles a case. Maybe you could share with us what it means to be settlement ready and why it's so important for lawyers and law firms to have a settlement strategy along with being prepared to litigate cases.
What I see is a lot of trial lawyers will spend years perfecting their voir dire and their jury selection. They'll spend years perfecting, their openings and closings. And then they won't really spend any time thinking about the administrative processes that have to happen post-settlement. So what I always recommend is for lawyers to sort of explore some of the questions that arise post-settlement, whether that be the bankruptcy issues, the probate issues, just different release language, making sure that, you don't want to be dealing with your retainer agreement post-settlement, right? You want to figure that stuff out in advance, and making sure that someone who's an expert in settlement is there to sort of hold your hand through that. Being settlement ready is just making sure that you have workflows and processes in place once the case resolves. And a lot of firms have these and they may not be the most effective, or a lot of the firms don't even have them. They're just trying to get that case resolved. It's a part of a law firm that needs more focus, in my opinion. It's part of the reason why I focus on this area of the law and try to raise education around some of these issues.
Sam, what are the keys to being settlement ready?
I really think it's three things. First, you want to build your processes, making sure that they're effective and efficient. Second, you need to assemble your team. You need to make sure that whether it's in-house or it's outside vendors, that you have the talent and technology to pull off all those different processes. And then finally, it's about focusing on the client experience and making sure that they're going to have the smoothest possible transition from personal injury litigant to personal injury settlement recipient. That process, if it's for the client, it's built with the mindset of being for the client, it will be the most effective.
Sam, what are some of the risks of not being settlement ready?
Well, first of all, I just don't like inefficient processes, right? Anyone who's running a business knows inefficient processes are costly. So it's going to impact your bottom line. Second, bar complaints. If you're not aware of all the different issues around settlement, you are going to receive ethical complaints that will tag onto your license and could threaten your license. And so to those who are not taking the time to be settlement ready, really, at first, it's going to impact your business from a financial standpoint. But second, you have a fiduciary duty to your clients, and you do not want anything negative to happen around your law license.